Right, let's get some analysis on this now. Legal expert advocate Zola Majavu joins us for more on this case. Advocate, good to have you this evening, and thank you very much for your time. We are involved in a process called a trial within a trial. In South African law, I believe this is a method of determining whether admissions were made freely and voluntarily. Now, we are, of course, beginning to hear affidavits containing what otherwise, for a layman, is a case completely unrelated to the trial that we were dealing with. We were dealing with a trial of a botched robbery or robbery gone wrong, and now we are hearing evidence that is going to do with contract killing. To a layperson, is this derailing the case in terms of the evidence that has been presented here? And is that a strategy, is that a tactic, is that deliberate, or is this now almost muddying the water?
Good evening, Mr. Mdluli, and good evening to your wonderful viewers at home. Let me start first by correcting my title. I do not answer to the title of advocate, lest I get into unnecessary trouble. So you can just call me Mr.
My apologies. My apologies. My apologies.
No, that's in order. You're not the only one who dresses me in those borrowed robes, but I take it well. I think firstly, and I'm going to try to break it down in very simple terms, hoping that the viewers would understand. The issue that is occupying the court's attention at the moment is a very important issue. It is central to the guilt or otherwise of at least some of those accused persons who are said to have confessed. Now, what is a confession? A confession is the statement that is made freely, voluntarily by someone in their sober senses, and in some instances reduced to writing before the relevant presiding court official in the form of a magistrate. Now, in a confession, the person who confesses, the confessor, basically admits to all the essential of the offenses with which he or she is charged. In this instance, they are facing charges of murder, amongst others. So in a confession by the person who claims to confess, you would expect that person to admit that on such and such a date, at such and such a place, I, Zola Majavu, intentionally killed Mr. Senzo Meyiwa using a firearm, described the firearm by firing so many number of shots directly into his torso. I was not acting in self-defense. I had no right to do so. In sum, that would be a confession, which, if it is found to have been obtained lawfully, and I'll come back to this point a bit later, that is pretty much the end of the case for that particular person who has confessed, that the charges that the state has put against him, he admits on his own. And if that confession is accepted, then he has pretty much convicted himself. Why is this important now? It is important because the state, being the party that bears the onus of proving the guilt of the 5 accused persons beyond reasonable doubt, they have to adduce evidence before a court in the form of witnesses who were there, witnesses who might have been told other things that they subsequently confirmed. But also, the state says, we are armed with a confession by accused number 1 and 2, in which they implicate themselves fully. And they are saying, we want to rely on this evidence to prove their guilt, as we should. The defense, on the other hand, knows, and they say, we have to make sure that that confession does not see light of day in court, because if it is found to be admissible, it is pretty much game over for accused number 1 and number 2. Now, because the admissibility of that confession is called into question, the main trial then pauses. Then you go into this stanza of the proceedings, which is called a trial within a trial, whose sole purpose and only purpose is to determine whether or not the document that purports to be a confession was obtained lawfully if you test it against what the law requires.
Yes.
Free and voluntariness, without undue influence, and in your sound and sober senses.
Yes.
Now, the defense, in trying to rebut that proposition, they are now coming, and not the defense in themselves, because they act on instructions. They are now coming up with a version that says, yes, the confession exists, but it is not a confession in the true legal sense because it was extracted through unlawful means. That is why the allegation that number one or number two were assaulted.
Right.
So if as a result of an assault, it will not be admissible, and therefore the state will have to proceed to prove its case through other evidential material, excluding this confession. So it's a very important exercise, and I'm not surprised that it has engaged the court's attention for this law. So it is not a peripheral issue, it is the central issue at this stage.
But here's the confusion, here's where the confusion comes in, is that up until this point, for a large part of the year, we have been engaged, at least the state, with evidence that talks about beer cans and people walking in and out and who jumped the fence first and how many shots were fired, what did you see when you were coming and so on and so forth, talking of a botched robbery. Why would a state go through all that when they've got these two admissions which are telling a completely different story as opposed on the motive? Maybe the details as to how it happened would be similar, but on the motive that is completely different to what have been being pursued right now. And that detail is only now emerging now in the trial within a trial.
Firstly, you must appreciate as lay people that the state, through the prosecutor, dominates the proceedings. There is a Latin nomenclature that says they are dominus litis. So the state decides who to call, when to call, in the exercise of its evidential duty. So they may be criticized for not having started with this, but it is really of no moment for us engaged in lawfare on a daily basis. The state has to pick an opportune moment at which to call its ace as a star witness, if you so wish. But I can understand someone would say, if you have a confession, have it tested right at the beginning so you know either it is accepted or not accepted. If it is accepted, that is game over for accused number one and number two. If it is not accepted, of course, then you have to go through what the court has already gone through. So I can understand where you are coming from, and the prosecution cannot be faulted, neither can you be faulted from at least forming that particular view as a lay person. But the trial within a trial is very central because it may significantly shorten the balance of the court proceedings, at least insofar as they relate to the confessors.
Yes.
Because in a confession, and if a confession is accepted as admissible, it is only applicable against those who made it. So Thabo cannot confess, and in his confession he implicates Zola. Thabo can only implicate Thabo. Zola can only implicate Zola, and not number 3 and number 4 and number 5. So that would not signal the end of the trial, at least insofar as the other non-confessing accused persons are concerned.
I see. Draw a distinction for us in terms of admissions. What is an admission and what is an informal admission? And what is a relevant statement or is an irrelevant statement? How does the court treat all this information?
I think we shouldn't get lost in nomenclature. An admission simply means if I say Thabo kicked me in my groin, and Thabo says, I accept I kicked Zola in his groin, but I did so because he was about to stab me. That is an admission, but that admission is negated by a possible self-defense. So it may well be that the reason why Thabo kicked me may be negated by what he was trying to obviate, but it nevertheless means you are admitting to the elements of the offense with which you are being charged. Now, when the court decides to weigh the probative value of that admission, it will have to check whether or not that admission is displaced by other possible defenses. Absent any defenses, those admissions are formal admissions, and they can and will be used against the person who made them. Similarly, with the pointings out, so you may admit that I killed Mr. So-and-so and I buried his body in a bush somewhere in Bushbuck Ridge. Over and above having made that admission, which is formalized in a confession, you then agree on your own to say, I am even going to show you where I hid that particular corpse. That exercise of you going to show the police where you hid the corpse that you said yourself you killed is called a pointing out.
All right.
And it is also a form of an admission which will be admitted into evidence against you, the person who made it, provided it is obtained through lawful means, meaning you were not promised some benefit, you were not beaten up, you were not high on nyaupe or anything of the sort. It must have been done so freely and voluntarily. And that is why at the end of the trial within a trial, we would then get a sense of how long or how spectacularly short the trial may be. But it is a determination that the judge is yet to make.
So it can go either way. So let's firstly look at one aspect of it, which you have already touched on, right? In their defense, right, the defense is saying, yes, there is a confession statement that was obtained. And they are first saying it was obtained through violent means. Today we heard that there was a benefit, for example, that was promised. And there's a third issue now that is beginning to emerge, that the legal rep was actually not the legal rep. And they say, no, we're going to look at a TikTok video that is going to show that this particular accused said this is not my legal representation. What is happening there? Because the courts now have turned to say, come up with heads of argument to say whether or not that evidence or that TikTok video, that recording, can be admitted as evidence in this court.
Firstly, in my respectful view, it's a storm in a teacup, and I will tell you why. The issue for determination is whether or not the confession was given freely and voluntarily. If the idea is to suggest that when such a confession was taken, the person who purported to have been a lawyer, Mr. Njiako, was not a lawyer acting on instructions of accused number one, it still does not take the matter further, because then the person who made the confession or who made the election to make a confession could have insisted on their rights to proper legal representation or legal representation of their choice. So it is of no moment with respect. The second issue is, if such a person was not acting on the instructions of accused number one, in that particular instance, why did that person appear in two different courts on ostensibly the instructions of accused number one? That negates the proposition that he was not an attorney of record for accused number one. But most importantly, if someone wants to rely on some TikTok footage or what was said in another court, there's a procedure. You don't just take a video footage and play it before another court, a high court for that matter, and say, look what was said in another court, and you expect that the presiding officer in the trial, within the trial, is going to accept that. I'm not surprised that the judge said to the parties, file a heads of arguments, because it is not as simple as the defense who raised the issue would want you to believe. There is a particular procedure, and I am certain Advocate Baloyi would not let that one slide. Yeah. He's going to, I think, direct them to the provisions of 235. I might be getting the number wrong, but there is a particular process in which judicial proceedings are authenticated. So it is not as simple as that. And if you ask me, is that going to take the defense case any further on that very narrow issue of negating the lawfulness and voluntariness? I think without preempting the outcome of the judge's decision, the answer is in the negative.
Yeah.
That is why I said it is, in my respectful view, a storm in the teacup.
Let's stay right there. You've dealt with that one. The other two issues then of assault as well as soliciting a bribe. Who has the honors to prove that statement in terms of law of evidence here? To prove a case, we say you need evidence. So who has the honors to present the evidence that says, indeed, I was offered 3 million, or indeed, I was assaulted?
It is the accused person. Because remember, all the state has to do is to say, here is a confession. And once the existence of a confession is on the table, there is a reverse onus on the person who seeks to negate the lawfulness of that confession. So if the accused person says, I was assaulted, he still has to get into the box so he can be cross-examined himself, like Gininda and others were cross-examined, to try and negate or prove that he was indeed beaten up or assaulted. If he says, I was offered a bribe, he who makes an allegation in our law must prove it. So the person who makes the allegation that he was offered a 3 million bribe would have to himself get into the witness box, testify, and produce some form of corroboration to his allegation. It is not enough for his lawyer to say, my client says that he was promised 3 million, because Gininda has denied that. He says, I didn't have a budget. There was no need to bribe anyone who has already indicated that he was willing to do this freely and voluntarily. And in any event, the people that he seeks to implicate were already themselves within the net. So there would have been absolutely no benefit objectively as to why such a proposition would even grow legs. If it does grow legs, it will be very short legs. But we are yet to hear what accused number one has to say on that score when he takes to the stand. Right. He must take to the stand. If he doesn't, that particular allegation is not going to be substantiated because it was made from the bar by his legal representative, and the person under cross-examination, Brig Gininda, denied it. So the judge will have to weigh what is before him as proven and tested evidence. And so far, it is still early days. But obviously, the indication is to suggest that the freeness or voluntariness of that confession is negated by a promise of some financial reward. And that is the purpose why it is brought. So is the purpose why the assault issue is brought, because they are trying to negate the voluntariness and freeness which ought to have accompanied that particular confession. That there is a confession is a given. The issue is whether or not that confession was extracted lawfully.
Now, you've aptly put it, you said this will then, whatever outcome here from this trial within a trial, will tell us how quickly this trial is going to proceed or how short it is going to proceed. Let's say it goes the way of inadmissibility. What happens to this story of a contract killing, right, or a contract murder? Is it still going to be entertained then in a trial, or does that mean it's the end of that particular confession and this court is no longer going to entertain whatever would have been contained in that admission?
No, that story or that proposition is not dead. But if it were to be pursued, it would have to be corroborated by other people other than Brig Gininda, because Brigadier Gininda has referred to it. Even if the court were to rule against the admissibility of that confession, the state is not stopped from leading other evidence that tends to support that proposition that you are dealing with a contract killing. The fact of the matter is, it is a murder that is unlawful. Whether you clothe it under the form of a contract killing, that's linguistic gymnastics, and it is good for media reportage. But the fact of the matter is, the state is still under a duty to prove the guilt of all 5 accused beyond reasonable doubt. And it will do so by relying on documentary evidence, by oral evidence from direct persons, or hearsay, provided it is corroborated later by people who will be called to testify in a court of law. So it would not be game over, so to speak, for the state. The state still has a list of over 100 witnesses that it may wish to call. Some it may not call. If it doesn't call, then it is open to the defense to then call those witnesses, provided they believe that they would assist them in their case. People were saying, why is Ms. Khumalo not arrested? And I know you haven't asked me.
I was coming to that. I was going to say to you as we wrap up, if it goes the other way and the court says, this are admitted, these are confessions are real, are true, they were done voluntarily, they were done freely, there was none of that. Is now the NPA obligated to act?
It is up to the NPA. They are called the National Prosecuting Authority. They act independently. It is up to them to evaluate the evidence that they have. Because what it would simply mean is Ms. Khumalo would not be automatically convicted. she will still be entitled to the presumption of innocence. She will still be entitled to all her Section 35 right that says you have the right to remain silent, and whoever makes allegations against you must prove them. She will have the right to cross-examine everyone, including Mr. Ntanzi, Mr. Njiako, or any other person whose statements are going to be used against her. So she too will be entitled to a fresh trial if we get there. But if you ask me, my guess is probably not, because what people think is a bombshell that was disclosed over the past 2 days, that is not a bombshell, because those statements, including the said confession, were given to the defense as far back as a few years ago when the docket was disclosed. The state knew about it, the police knew about it, and I'm sure the police would have followed it up, and for whatever reasons, they might have taken the view that the allegation is not substantiated. I don't speak for the police, I don't know. Because if they found that there was some substance to the allegation, it is such an important cog in the wheel of this intricate case. You would have expected that Ms. Khumalo would be accused number 1, or at least accused number 6, having joined the people that say she was the mastermind behind in the dock. But none of that has happened. She's also not on a list of witnesses to be called by the state. So that is very telling. So I wanted to debunk that myth, people thinking that, hey, now she's going to be arrested or anything. No, not anytime soon, not by a long shot. However, if the prosecution or the state independently gets hold of other evidential material that they believe is credible, that implicates her, there is nothing stopping them from preferring charges against her separately or independently. But they've made a call on who to charge, and the 5 people are the ones that the state is pursuing, not Ms. Khumalo. It doesn't matter how juicy we may think those revelations are. And as a matter of fact, to the extent that those revelations were made by Brigadier Gininda, that is hearsay. And the judge already indicated that that is hearsay, because Gininda was not there when those revelations were made. At the very least, the person who can give direct evidence about that which is contained in the confession is the presiding magistrate before whom that confession was given, and it is she who then reduced it to writing. So she can give direct evidence about exactly what accused number 1 and number 2 said.
But, but as you put it earlier on, it is definitely a bombshell for accused number 1 and 2, because they are implicating themselves. So they are saying, yes, I took the shot. I'm the one who bought the guns, or I'm the one who sold the guns. So for them, it is directly implicating them.
It's not a bombshell. They've known about it. This was contained in the docket contents that were disclosed to their own defense. And that is why, in fairness to my colleagues, when they are cross-examining, they are saying, my client's instructions are this. Meaning they looked at the confession, they discussed it, and the lawyers were told what to say in response to those allegations. There's nothing, it's not something that the lawyers would have dreamt up. So it is not a bombshell from a timing point of view. But they are spending sleepless nights because who in their sober senses would have volunteered that information except themselves? They did. Now they realize that they're in a pickle. Now they are seeking to negate it. And the only way in which they can negate it is to say, we didn't bring a free and voluntary mind to bear. We were coerced or otherwise induced. Coerced by being beaten up, induced by being promised $3 million. It's a lot of money. A lot of people can return $3 million. But Gininda has denied it. Yeah. So they must then come into the witness box so that they too can be tested by the prosecutor in the form of Advocate Baloyi to test the truthfulness of that allegation.
Mr. Majavu, I appreciate your time. Thank you very much for your intervention tonight and that clarity that you're bringing there. Legal expert Zola Majavu explaining to us these developments that have been taking place in that Pretoria High Court.